Yeah, so Ernest, in New Hampshire, what does informed consent require beyond just signing a form?
Yeah, so it's got a very specific definition, and actually, I'll go straight to Black's Law Dictionary. It's the dictionary for lawyers. Uh, Informed consent is defined as a person's agreement to allow something to happen, made with full knowledge of the risks involved and the alternatives. So it's got a very specific meaning. So it's not just signing a piece of paper, right? I mean, you have to be you have to agree with full knowledge of the risks involved as well as the alternatives. So we talk about informed consent. It's just making sure that you actually know what you are consenting to. And the way a provider does that is they let you know, not just what you're going to do, but sort of all the potential risks or fallout from that procedure.
So, can a doctor or a hospital still be held liable even if the patient does sign a consent form?
Yeah, definitely. You know, there are a number of scenarios where informed consent doesn't actually occur, where it doesn't meet that definition. So they definitely could still be held liable. I mean, there are numerous examples, and I'm sure we've all been there, right? You're standing at the counter, you're speaking to one of the staff, and they have that little black rectangle with the plastic pen, and they'll say, "Okay, we just need to have you sign some consents. This is just your consent to be treated." And you don't even see your signature. You just squiggle in the little box,
Hmm.
and they say, this next one says, we can do X, and you sign it. This one says you'll pay your bills, and you sign it. Well, I mean, that's not informing you of anything.
Hmm.
They've so systematized it, they take the informed out. You're signing it. Are you consenting? I mean, you're signing something, but do you know the risks and alternatives? Now, good physician, maybe you're going through that process, but still, when you get in back in the room with the physician or the practitioner, they really walk you through those things. But that signature alone in that process that we've all seen before, it's not sufficient. So it doesn't make you informed. That's not going to cut it, and that's not going to prohibit you from bringing a claim if one of those risks comes to reality and you never knew about it because they didn't bother telling you.
So, does it come down more to a conversation that you're having with your doctor, and your doctor really sitting you down and explaining, like, look, these are the things that can happen? Do they need to, assign, percentages to that and say, look, in 5% of cases, this procedure could result in this. What is that conversation like, or what should it be like?
Yeah, I mean, some of that when you talk about the percentage of risk and whatnot, I mean, really those are kind of jury questions. Are they sufficiently informed? Again, it's going to come back to the definition. Do you have full knowledge of the risks? What's full knowledge? Again, ultimately, that's for a jury to decide. So, do they need to articulate a percent risk? Maybe not, but they need to reasonably inform you of kind of what could happen and the things that could go wrong. Because can you truly consent if you don't understand the things that can go wrong or that commonly do go wrong? And the answer, under the law, is that you can't. And if you don't have that consent, the doctor's got a problem. So in terms of that conversation, I wouldn't say it's so much about a percent or necessarily every particular outcome that could happen. I don't know that it's reasonable to expect a physician to even necessarily know every single outcome. But kind of the major risks or the known risks and those sorts of things, they really need to make sure that you understand those so that you can consent.
And then the other half of that you mentioned is the alternatives. So they should be explaining to you that, hey, if you opt not to have this surgery or this procedure, these are the other options that you have, and then these are the outcomes that we might expect from those procedures.
Yeah, that's right, John, and that's really important because as idealistically as we'd all like to be, and as uh, idealistically as we'd like to look at the medical profession, It's a profession and it's a business. So these people get paid for procedures. The more procedures, the more sophisticated, the more complicated, the more extensive the procedure, the more gets billed, the more the doctors get paid. They have an incentive to perform procedures. And oftentimes they perform procedures that don't need to be done. And so you don't, you know, you are not informed to the point where you can consent if no one has stopped and told you, hey, you don't necessarily have to have this cut out or this removed or what have you. Here are some other options and give you those options. So, they can blow informed consent pretty easily by doing what unfortunately a lot of physicians do, which is look for a procedure to do. All right, I've got a patient. What procedure can I do? Because I can bill $10,000, $20,000, $50,000 if
Mm.
I do this. So their incentive, it's basic economics, is to do the procedure, and that's not necessarily what's right for you. So patients need to be informed, and if they're not, that can pose a real problem for the physician.
How do things like language barriers and maybe, like you said before, having a really rushed, conversation where you're not going in depth about these things, or perhaps you're even sedated, or you've excluded the family from your conversation with the doctor. How do those types of things affect whether or not consent was truly informed?
That's right. I mean, it just goes back again to the definition, full knowledge of the risks. Are you in a circumstance where there's a language barrier and, it's clear to whoever's speaking to you that, you're not necessarily getting it or understanding it? Do they make provisions to ensure that you do it? Are they putting you in a circumstance where, a reasonable person is not necessarily going to know or is not necessarily going to make the right decision? I can give you an example. I have a case right now where I have a client who was gowned up, ready to be rolled back for a major surgery, and they brought in the consent documents to have her sign. They explained nothing to her, had her sign it. The doctor claims that he showed up. The purpose for her procedure, without getting into too much detail, the purpose for her procedure turns out didn't exist. So the underlying reason for the procedure didn't exist. They found out
Hmm.
that morning. The doctor claims that he went in and talked to her and said, "Hey, this condition for which you required the surgery, turns out it doesn't exist, but you can go ahead and do it anyways because it could have these benefits, or we could put it off." That's his story. I mean, I personally don't believe him. I don't think that conversation ever happened. Um, but even if it did, this woman's gowned up. They just had her sign the informed consent agreement. Which, by the way, when you go into surgery, what do? You take off your rings, you take off your jewelry, you take off your glasses. So they've got this consent form with tiny writing, and they're saying sign here and explaining nothing. And she's signing it scared, about to go into major surgery. And then, according to the doctor, he comes in and has this other conversation with her, which again, I don't, the evidence doesn't support that ever happened. But he's claiming that conversation happened. Well, even if we take him at his word that that's what happened, is a person have the full knowledge of the risks when you've got them signing a piece of paper with small print that they can't read, that you're not explaining anything to them that's written there, or what you are explaining, if you actually are explaining it to them, you're explaining it to them as they're laying in a bed in a gown with the operating room right next door, getting ready to wheel in.
Right. If you're saying that, like, hey, you don't need this procedure, shouldn't you be saying, you know what, just get dressed and go home?
That's right. That's right. Or we're going to call this off. Let's meet next week. Thank God the underlying condition is not there. Let's meet next week and let's talk about alternatives.
Right.
Give you a chance to think it over. This woman's, on the gurney ready to go in. So, all those circumstances matter. And those are those things that you really need to look at. That's why you need a lawyer that understands these concepts, that can look at these things, and help guide you. And that's why, this, like, well, there's this consent form I signed. I mean, so what? Let's take a look at it. Let's figure out if that's real.
Should a patient or a family of a patient in New Hampshire be proactive and maybe ask some, particular questions? And if so, what are some of the questions that a patient should ask of their doctors before a major procedure?
Yes, I mean, I think informed consent is not just for lawyers, right? Informed consent is a concept and an idea that's within the medical community as well, because there's a moral aspect to it. I mean, if you're going to ask a person to, or suggest a person goes through, sometimes life-altering surgery, you have a moral obligation to make sure that they understand what's going on. And so, yeah, the patient really should be proactive. Again, doctors are not always good, with all due respect to the profession, are not always good at explaining things. So you need to ask questions and continue to ask questions until they explain it to your satisfaction. Don't be afraid of your doctor. A lot of people are intimidated by doctors. Ask them those questions. Be frank. Doctor, you're using a term I don't understand. Could you break this down and explain this to me? Do what you can to make sure that you are informed as well. And frankly, today, with today's technology, one of the things that I would tell clients as well is, before you go in there, this is not like the old days of WebMD, where you came into the doctor and you had figured out from your research online that you were going to die. And so you come into your doctor terrified, and your doctor rolls their eyes at you.
Yeah.
We have artificial intelligence now, and some of these systems, these chat GPTs, Grok, these various systems are actually quite good. So sit down and do those questions with AI before you go. And, not just like, diagnostic type stuff, like, what do I need? Ask it to explain to you what terms mean, until you kind of have an understanding, or what you think is an understanding, of what's going on. Then when you go in to talk to the doctor, you at least have an idea of what's going on, and you know what questions better to ask. When they start coming back at you with terms, maybe you understand them, you don't have to spend as much time asking him to explain them. And really, that gives you a good foundation. Maybe the AI is not exactly right, but it gives you at least a good foundation to come in and kind of help yourself know what to ask, so you can help that informed consent process, so you really are informed.
What if a patient believes that they've signed some sort of a waiver of liability, or a promise not to sue their doctor or the
Yeah.
hospital? What happens in that sort of situation?
Yeah, I love that question, John, and I'm glad you asked. We all anecdotally, before I was a lawyer, I had heard this. We've all heard that. Oh, but you can't sue because they have you sign something promising not to sue. I hear people say stuff like that. Well, they sign a waiver beforehand saying you're not going to sue. All right, listen, you cannot waive a lawsuit for negligence or medical malpractice in advance. I don't care what they had you sign. If they commit malpractice, we can hold them accountable. So they may, in fact, it's not necessarily likely that the forms that they have you sign are going to say, I promise not to sue, or whatnot. But even if it does, it's not going to be enforceable. Oftentimes and this doesn't have to be physicians, this can be anything, right? If you're going bungee jumping, you sign a waiver that says, I promise not to sue, and the cord breaks, and you end up on the ground disabled for life. You're not just out of luck. You can't waive that. So even when they do have those waivers, oftentimes they operate for the purpose of scaring you off from ever making the phone call. And that's not something I can survey, but I think a lot of clients with good claims never call lawyers because of that nonsense. It's an effective tool. I mean, if I were on the other side, I would tell them, put that on there. It's totally ineffective. It doesn't mean anything, but it might discourage someone from suing you.
Mm-hmm.
When you're driving behind these big vehicles and they say, not responsible for falling debris, that might hit your car. Well, I mean, right? It's like Michael Scott declaring bankruptcy. Yeah, you can go right on the back of your truck. I'm not responsible for running over your child.
Right.
It doesn't matter. Your doctor can write, oh, you're waiving the opportunity to sue me if I cut off the wrong body part. It doesn't matter. Don't be scared off by that. You can sign that. I don't care. Call us. We'll look at that. That's not going to be a bar. Nobody gets out of malpractice because nobody in advance can waive a malpractice suit against them.